What's the update for Devon versus Brenay regarding alimony and equitable distribution? As of May 20th, there was an attorney-only hearing where the attorneys presented an amended scheduling and discovery order for the judge to sign off on. Now that that's been uploaded to the docket, we're going to break it down. As always, certified law nerd, bona fide non-attorney, not legal advice, just my interpretation of what I'm reading in the docket. Let's begin. The amended order was filed on June 3, 2026, and it deals with the equitable distribution side of this case. Equitable distribution is the part of a divorce case where the court deals with marital property and marital debt. Now, in North Carolina, equitable distribution is about sorting out what belongs to the marriage, what may belong to one person separately, what debts exist, and how everything should be divided. The law starts from the idea that a 50-50 split is fair, but that is not automatic. If the facts support it, the court can divide things differently. The first page mostly gives us the background, who appeared for each side, when the equitable distribution action was filed, and a few basic facts the parties agree on, including jurisdiction, the marriage date, and the separation date. Now, this is interesting. The order says that neither side has served their equitable distribution inventory affidavit yet. An inventory affidavit is basically a sworn financial disclosure. This is where each side lays out the property, debts, values, and classifications they are claiming in the equitable distribution case. Simply put, before the court can divide the marital estate, both sides have to put their financial cards on the table, if you will. What's marital? What's separate? What debts exist? What assets exist? What do you think those things are worth? That is the purpose of the inventory affidavit. And now the court has set deadlines for those affidavits. The moving party, which is Devon, has until July 3rd, 2026, and the responding party has until August 3rd, 2026. The order also confirms that the parties have to participate in family financial mediation. So basically, this gives both sides a structured opportunity to try to resolve the financial issues before the court has to decide them. Here, the parties are ordered to attend that mediation with a neutral mediator. The deadline for that is September 21st, 2026. The fees are listed here, so $175 for an admin fee, $250 per hour, and that has to be split 50-50 between the plaintiff and the defendant. It also appears that discovery is also still pending. Remember, discovery just means both sides are still exchanging the information, documents, and evidence connected to the case. According to the order, both plaintiffs' and defendants' discovery responses are currently pending, and those responses have to be mailed to the opposing party by September 11th, 2026. Expert witness disclosures would be due that same day. And lastly, we see a little of the court calendar. Assuming that Devon and Brenay cannot resolve this via mediation, the initial pretrial conference is set for October 13th, 2026, and then there is a final pretrial conference set for October 29th, 2026. It is saying here that there is no specific date for trial yet, but the order says that trial would be set according to the court's initial pretrial conference, so that October 13th date. That would be around the time that they would decide when they would proceed with trial, and they do estimate that that trial length will be 6.5 hours. The remainder of this year is really going to be about the deadlines in this case, so inventory affidavits need to be served by July 3rd and August 3rd. Discovery should be completed by September 11th. If mediation occurs, the deadline is September 21st. If they can't resolve this via mediation and need to go to trial, then initial trial conferences will start in October with a pending trial date. As always, I will keep an eye on the docket, and I'll catch you in the next one.